Hi folks, so I got a bit of feedback from a video I recently put out concerning the legal name and whether or not it's copywritten and whether or not you're committing fraud by using it. A young man by the name of Rebuttal put out a YouTube video called Point of Clarification. Feel free to look it up. It's a 9-minute video. I'm going to play this and repeat it and then interrupt it along the way to address some of the points he's raising. I hope you don't mind. I'm trying to give him, fair, I don't know, sharing the podium kind of thing. He has a view completely different from mine. So we're going to have a little discussion here back and forth. If he wants, we can have a Skype discussion on it and tape that, put it out. I don't care. I like the idea of getting some sort of dialogue happening on it. So I introduce you here to Rebuttal. Sure, no idea if that's his name, but that's what he's going by. So we're going to hear what he has to say, and I will be interjecting along the way and giving counterpoints.
Hey, what's going on, everybody? It's me again. Saw videos and commentary coming out talking about the people who expose the legal name fraud. Don't talk to them, tell them to fuck off, say to their face that it's bullshit, and Okay, so that's great.
Okay, so I might have been a little bit harsh there. I apologize for that. I don't really want anyone going up and telling you to fuck off into your face, but I am telling you you're very wrong in your beliefs here, and it's demonstrably so. So I do want people to listen to you and at least treat you with the dignity enough for that. So I apologize for that anyways. Don't tell him to fuck off. Listen to what he has to say, but then use your noggin and figure it out.
Not the first time that's happened. Definitely not going to be the last. I'm not worried about it at this point. I've dealt with a lot of people. Okay, so I'm going to cover some of the points that were made in the video, and it's important to pay attention. I say again, do not believe anything I say, because that's the problem, is people say shit and then a bunch of people believe it, and then now people don't know anything anymore because they believe so much shit. Okay, so don't believe anything I'm saying. Fact check what I'm saying. Okay, cool.
Don't just fact check. Once you have the facts, watch what he does. He'll say fact check and then he jumps to a conclusion. Don't jump to conclusions either.
Claim 1 and 2 are kind of one and the same, so I'll cover it with one explanation. Okay. You don't copyright a name, you trademark a name is 1, and 2 is the birth certificate is copyright prior to your name, and it only covers the information on it prior to that point. Okay, the maxim of law. He who creates owns. People are acting in these capacities using the...
Okay, see, he's trying to raise up a maxim, and what he's doing is completely ignoring the one primary statement, that being, you don't copyright names. He never addresses that. He's trying to bring a maximum into play, stating that he who creates owns, which is basically true, but not universally, not consistently. If someone makes something and then sells it, he no longer has right to claim to it. If someone makes something and gives it away, again, he no longer has the right to claim the ownership of it. And this is key, because although you didn't make your name, your parents did, and they gifted it to you. It's yours.
These names that they did not create. The parent or guardian made the name. It's not yours via creation. You didn't make it. You did not...
The parent or guardian made the name, gave it to you. It is yours.
The parents, what they intended was to, it wasn't their intellect.
You can claim ownership of things you did not create.
The parents, what they intended was to, it wasn't their intellectual property, by the way. They took these sigils we call letters, and they put them in a certain order, creating a word, and then they put these words in order. And these words, when spoken, were meant to be a beckoning for us. And then they put it on paper and registered it, adding it to the registry sheet thrown in the registry book. Got it? It's not just the birth, it's the whole page. Birth certificate, birth certificate, birth certificate, single page. All right, got it? All right. 2. For you to commit a fraud, it requires an intent.
This is important. Every crime requires 2 components. One is the actus reus, you actually have to engage in an action, and 2 is the mens rea, where you actually have knowledge that what you're doing is wrong and you have guilty intent. criminal law requires these two components.
And I'm quoting here, quote, "An honest belief is in fact a very powerful defense against charges of fraud," end quote. If you guys have been looking into law for even a little while, you've heard this before. It's another maxim of law. Ignorance of the law is no defense. So if you...
Okay, here's the problem that he's making. When he's misapplying maxims, they're not universally applicable at all times. You have to know when to apply them. Secondly, ignorance has a component of ignoring. It comes from the word ignore. It's not merely not having the information. It's having the ability to have the information and ignoring it. It's knowing that there's something there and acting contrary to that knowledge. Not having the knowledge is not ignorance. So that what they're talking about there, ignorance of the law is no excuse, does not mean that an honest belief contrary to a reality is not a defense, because there's still no mens rea. It's not about ignorance here. It's about whether or not you have the intent to commit harm.
So if you have a really strong belief that you're not causing harm, but you're causing harm, then they don't care. If you're causing harm, you're causing harm.
That's not true. They do care. They always have to prove the mens rea. They have to prove that mental component of the crime. There's the physical action and the mental component. They always have to prove that. So him claiming they don't care, dude, that's fucking bullshit.
I don't care what you believe about it. You are personally responsible for your actions. Got it? Cool. All right, so I'm going to cover this one separately, but we'll go on from there.
Mens rea, actus rea. If you're studying the law, look up those two things, and I will establish and prove to you that there is no mens rea component in what he's describing as a crime.
All right, so I'm going to cover this one separately, but we'll go on from there. Okay, the people talking about the crown aren't agents of the crown. I don't need to, that's a logical fallacy called an appeal to authority. I don't need to be employed by...
No, that is not an appeal to authority. That is merely pointing out that you lack standing to make the claim, that you're making a claim on behalf of a third party who is not even there and is not making that claim themselves. It's like I'm riding a bike and you're coming up and saying, you don't own that bike, that guy over there does. You're not making the claim for yourself. You're making it for a third party who is not making the claim and is saying, I don't know what the hell he's talking about. I recognize that as your bike. That's not an appeal to authority. An appeal to authority is when you point out the standing of another party as being more qualified to act, and therefore we should listen to them and give their words weight absent any logic or reason.
By the organization to read the stuff that they put out and repeat it publicly. I don't. That's like saying that people who realize that mercury in vaccines need to be doctors to be valid to say that mercury is bad for you. Okay, come on.
No, it's not. I'm not saying that at all. What I'm saying is that if you want to claim that a third party owns something which I consider mine, it's up to that third party to act and to make that claim. That's all. And it's not saying that that third party has authority greater than anyone else making the claim. I'm just pointing out that you personally do not have the right to make a claim for that third party. And until I hear it from that third party, your claim is a fart in a hurricane. It really means nothing.
Come on. But okay, these two claims are in the same. It's never the Crown making this claim. I'll get to that. And an open claim was never made. It was the Crown that made the claim. In 1998, there's a document called Crown Copyright in the Information Age. It was released in 1998. Dr. David Clark, which at the time was the Chancellor of the Duchy of Lancaster, which is, he's, hold on, I actually have how he gets that gig. Okay, well, here real quick.
See this is an appeal to authority where he starts spouting off this man's qualifications. And due to these qualifications alone, we should pay extra attention to what this man has to say. That is an appeal to authority.
Okay. The Chancellor of the Duchy of Lancaster is appointed by the Sovereign on the advice of the Prime Minister, and the Chancellor is answerable to Parliament for the governance of the Duchy. He works for the Crown. He deals with legal and finance and stuff like that.
He's the authority. Listen to him.
Okay, so he's with the Crown. And he released this document. And in the document it says, let me find the page real quick. Look it up for yourself. It's Crown Copyright in the Information Age. Make sure that you click on the opsi.gov.uk PDF. It's 54 pages. opsi.gov.uk, for people who don't know, is the United Kingdom legislation page, okay? So this is on their legislation page under the advice column. All right, so what we're looking for is page 29, and if your pages are not numbered, it's Annex A. And it states at the top that this is categories of Crown copyright material, and there's an explanation sentence to get you in the mentality of what they're talking about. The following list, which is not exhaustive, indicates the wide range of material which currently falls within the scope of Crown copyright. Great. And this is one of the things. There's a bunch of stuff that they claim to copyright, but this is the thing that we're talking about here. Okay, so I quote. They say this is copyrighted. Quote. Documents which contain information relating to a particular person or persons and which, if copied, could be open to fraudulent use. End quote. And they have an example explanation column next to this. And in the example explanation column of what I've just read, I'll quote that too. Quote, birth, death, and marriage certificates, driving licenses and passports, land certificates and office copies of registers or title sheets. End quote.
Okay, now play that back if you need to and ask yourself this. Did you hear the word names?
Okay, so like I said earlier, it's registered, it's added, the birth certificate's registered, it's added to the register sheet. Yeah, it's copyrighted here as well, but once it's registered, it's added to a register sheet. Okay, so it's a whole page. They got the book, it's all right there.
The information on these documents is not part of the copyright. It's that simple. Names cannot be copywritten. They can copyright the document, all of these certificates, diplomas, whatever, and then that is what is copywritten. That's what can't be copied. The name that goes on these copywritten documents after the fact, that is simply not part and parcel of the copyright. And taking this and collecting them all doesn't somehow magically transfer that copyright to these names.
Okay, so it was publicly, openly stated. Anyone can look this up if they have internet access. This document covers in the beginning talking about green.
And also, anyone can look up whether or not you can fucking copyright names.
Going green. So they're putting it on computers now instead of wasting paper. So yeah, it's right there. Look it up. Don't believe me. Look it up.
Look it up and then look further onto whether or not you can copyright a name.
That's the whole problem, is people believing. Nobody has ever been charged, tried, or convicted for using a name. Using the name, going in there and identifying as the name is what gets them jurisdiction in the first place. That's why people go to jail for things that actually have no corporate...
Okay, so now he's shifting the entire discussion onto the method by which they gain jurisdiction. And that's not what we were talking about. The question is whether or not you're committing fraud by using this name, because it's copywritten and you don't own it.
Corpus delicti, things that cause no harm, or they think it doesn't have corpus delicti and they think it's not causing harm. This is how the game is rigged. It's a catch-22. To think that you are the name on the docket and show up to the courthouse and identify as that name without a bar card or any affiliation, any express permission from the Crown, you've already committed a crime because it's a commercial setting.
That's not true. It's simply not true. You have not committed a crime by doing that.
It's a commercial setting. You're using somebody else's copyrighted material.
See, his entire argument, he's claiming it's a crime because you're using someone else's copywritten material. But it's not copyrighted material at all, and it doesn't belong to the someone else he's pointing to, and the someone else he's pointing to is not making the same claims. He has no power to speak for any third party. I'll tell you this, when it comes to ownership as a function of law, if I claim my hat belongs to me and you want to claim it belongs to you, then you go ahead and you make your claim and try to take it from me. But to claim that a third party has ownership of my hat when I'm wearing it, and that third party is saying, dude, I don't know what he's talking about, you really have no standing fundamentally to make a claim towards my hat, towards my name. especially when the third party, you have no authorization to act for them. You have no standing in the case whatsoever. You're not claiming it for yourself. And the third party that you're claiming owns it isn't making the same claim at all.
Without their knowledge or permission in a commercial setting. That's the jurisdiction right there. They can do whatever they want to you after that.
I know that a lot of people are losing faith and trust in the justice system. I know there's problems with it, but it's not due to your name being copywritten, and it's not due to you committing a crime when you step into the court because you're using your own legal name.
But on the other side of that, I've seen people, I know people who have been dragged into court forcibly, and they didn't use a name, and nothing happened to them. They're completely fine. They're out there free. They're happy. So, I guess that's for me. I guess instead of speaking from opinion, it would be better if people actually went through the experience and talked after the experience, rather than giving an opinion with absolutely no experience.
Well, now I'm pretty sure he's not talking to me, because, son, I've had more experience than you can probably think of.
And
I've been doing this a while.
The copyrights are applicable to the works. I think that was just the last little one. Yeah, it's applicable to the works. So if you're...
Yes, copyright are applicable to the works. But if I write, let's say, a dictionary, let's say I pen a dictionary, can I then claim that the copyright includes every word within there and you can't use one of those words without my consent? If I write a musical piece and I manage to use every single possible note, does that mean from that point forward I own those notes? No. And here's the fundamental thing. Right at the beginning, remember what his first point was? Names can't be copywritten. He's totally glossed that over. He hasn't addressed it at all. And his entire argument is resting upon the mistaken belief that names can be copywritten. And he thinks that they're now copywritten because they're included. These names are included in a body of work, which is a collection of copywritten materials. He still hasn't addressed the simple fact, which is right from the get-go, names cannot be copywritten. He's just ignored that completely.
You're identifying as a white male, John Doe, this is your date of birth, whatever. If you're identifying as all of these things on that document, and the assumption presumption of law is to say, I'm not John Doe, I'm just John. Okay, and what's your birthday? And are you, and do you have your ID on you? And as soon as they see that stuff, all they want to do is they want to trick you into creating joinder so that you accept the surety for the person. That's all they want from you.
Okay, see, I won't argue that. He's pretty close to the truth. But in order to understand what the remedy to this situation is, we have to understand a greater depth of what the problem is. And that means realizing the truth of the matter. And the idea that our names are copywritten and that we're committing a crime when we use our legal names, that is full and complete wrong. And if you're operating upon that belief, although you might recognize the problem, you're not going to find the remedy at all.
They want you to accept surety. They want you to be liable for this dead thing that is fictitious. They want you to act in this capacity because then they can do whatever they want with you. Okay? That's how they did it. They didn't end slavery. They made it for everybody. So, yeah, as far as all this stuff goes, by all means, people, look all over the place. Look for answers everywhere. Ask yourself the questions. That's more important than...
Yeah, okay, well, and then he just winds down pretty much. So, yeah, I agree with him. Ask yourself questions. The list that he gave you, do you see the word names on it? If you don't see the word names, if they're making a list of what they can and cannot copyright, you'd think that they would put names on it if names was something they could do. All of his assumptions are pretty much incorrect. He's misapplying and misusing maxims. He's trying to claim that the creator of something is always the owner of it, ignoring the fact that such things can be sold and otherwise transferred through gifts, through inheritance, through all sorts of different ways. And the fundamental point that this all started on, he has never addressed, and that is names cannot be copywritten. And his next leg of his argument is that mens rea is not required to commit an offense, to commit a crime. And I'll tell you this, it most certainly is. So look up what constitutes a crime, and whether or not, look up mens rea and actus rea and see whether or not he is trying to argue that the mens rea component is not necessary for an act of fraud, and then look up what constitutes the elements of the offense of fraud. And realize this, when it comes to claims, this man is not acting for the Crown. He's not authorized to make claims for the Crown. He's not claiming your name for himself. He's trying to claim your name for a third party who is not making that claim at all. And what he points to as them making a claim is that page 29 of what he mentioned right here, where the documents are copywritten, and he is assuming that the information placed upon those documents is also somehow magically covered by the copyright, even though it's a name which can't be copywritten. So yeah, check it out. If you want to believe that some other party who's not even making a claim towards your name owns your name, you go ahead and believe that silly shit. As far as I'm concerned though, I own my name. I've got it. It's mine. I've got the right to use it, and I'm not breaking the law in doing so. And if someone wants to claim that I am, they have to have a claim greater than mine. So if you want to claim that the Crown owns my name, I want to hear it from the Crown. And until I do, you're just farting in the wind. So that's my rebuttal to his point of clarification. He's wrong on so many points, it's not funny. So this is, I'm pretty sure, what he was referring to. It's a thing on copyright written by the Chancellor of the Duchy of Lancaster. If you notice at the bottom, it identifies that this is a green paper. So this is what he's referring to, a green paper on Crown copyright. Now what's a green paper, you might ask? A green paper is a tentative government report and a consultation document of policy proposals for debate and discussion without any commitment to action. It's the first step in changing the law. Green papers may result in the production of a white paper. And this is the section that he's looking at. This is Annex A. It's an annex of a green paper, and at the bottom you see birth, death, and marriage certificate, driving license, and passports, land certificates office, copies. Registers or title sheets. Now he is assuming that this annex to a green paper constitutes a notice of a claim for copyright of our names, even though upon it you do not find the words notice, claim, or names. And yet somehow this is magically a notice of a claim that they have a copyright to unmentioned names. It's one of the silliest things I've ever seen.